Got that part right. All right. We are here to publicly deliberate case number 18-260X. It's Robert and Barbara Webbert, legal owners of 2401 Stringtown Road. This is a petition for special exception pursuant to BCCR 426.5 for a telecommunications tower with a height of 100 feet in an RC zone. This was originally granted below on 5/11/2022. I believe we had a evidentiary hearing de novo on 10/20/2022, where we had the petitioners. We also had pro se protestants in the matter. So I guess I'll start briefly by the preface. I think I spoke a little bit before the hearing because we had some folks who weren't lawyers involved, and just about the role of this board in such a situation. If we recall high school civics, there's branches of government, some that make laws, some that enforce laws, some that interpret laws. We are a quasi-judicial body, so we're in the interpreting laws business. So we really don't have the power to make the laws. So we deal with the laws as they are on the books. In this case, we have a petition for special exception. And I think I mentioned before that that term special exception is sort of a misnomer, meaning that in an RC2 zone, there's things that are allowed by right. There's things that are prohibited always, meaning that you can never have them. And then there's things that are allowed by special exception. And we know through the case law that special exceptions, things that are listed for special exceptions, if we look at the Schultz v. Pritz case, I had it a moment ago, and I think I just lost it due to my technical inabilities. Anyway, Schultz v. Pritz basically told us that there's a presumption that it's in the public interest to have these special exceptions. They wouldn't be allowed to be a special exception if the legislature or the county council in this case had not determined that there were situations where it was appropriate to have the special exception. And then the important other case that took Schultz v. Pritz a little further is the Attar case, which basically says that a special exception can be granted unless it's proven that the effects on a specific location are more intense or different than they would be somewhere else similarly situated in the RC2 zone in this case, meaning that there are certain effects of things that are baked in to them being allowed by special exception to begin with. And that's what we are considering with this cell tower and its 100 feet request for special exception. In special exception cases, we turn to section 502.1 of the Baltimore County zoning regulations, which gives us a list of factors where we apply those factors to the case at hand. Those factors are usually brought via expert testimony. And that's the second issue in this case, is the type of evidence that was heard via this board. We heard expert testimony concerning the aspects of 502.1 through the petitioner's case. And then we heard testimony from the protestants whose concerns were health issues. There was several articles that were brought to our attention, not via expert testimony, but we allowed them in for the weight, as we say, that they do deserve, but they did not come in through expert testimony. So with all that being said, I first want to say there is the evidentiary problem that the expert testimony that we heard in this case was uncontradicted. But the second issue, looking the Attar standard, if we were to accept the arguments of the protestants, the arguments that are being made are arguments that would be similarly made in any location within the RC2 zone. So when we're applying the Attar standard in the applications for special exception, while they may be valid concerns, that is not what defeats a special exception, which is clearly stated in the case law. So with those two factors, I really I'm not going to dig much further because one, on an evidentiary standpoint, looking at the expert testimony that is uncontradicted, and then an application of the Attar case showing that there's been no testimony that this situation or this locale is different from any other locale in the RC2 zone. So with that being said, I will turn it over to my colleagues. I'll start with you, Ms. Bernardi. Any thoughts on the matter?
Thank you, Mr. Chair. You covered all the issues. My notes that I had was related to the testimony that was given by the three experts. Mr. Shakala, his testimony was consistent, as you stated, with BCDR 426.9. The petitioner made diligent efforts to locate antenna prior to seeking this approval for the new tower. Testimony from, I think it was Mr. Tironi, regarding the setback requirements for the tower, and it far exceeded the setback requirements under PCDR. And then I felt that the testimony of Mr. Dugan regarding the radio frequency design and safety compliance, the reports provided addressed the health concerns raised by the Rice family. And I just want to say also for the record that, of course, understand the family's long history in the area, the health concerns that were raised, but what's before us is whether or not that special exception should be granted. And you already touched or addressed the Attar issue, and I just wanted to say related to that under the general welfare interest, I don't believe that any probative evidence was provided that showed there was any unique adverse effects that would be presented. So I don't feel that the protestants overcame the presumption that is provided in Attar.
All right, thank you. Mr. Pennington, any thoughts, sir?
I agree with both of you. Mr. Dugan's testimony was uncontradicted regarding the health, safety, and general welfare, and that was basically the only the issue under 502.1. I think it's satisfied. He provided some good testimony on the studies that were done, and it was uncontradicted. So I agree with the two of you. I also went through the 426 zoning regulations, 426, all the requirements there. And as Ms. Bernardi went through, they were all satisfied through the testimony and even the Tower Review Committee approval, and also the work they did with the Historic Trust and the neighborhood to reduce the height of the tower to help accommodate the concerns of the area. So it should be granted.
All right. Yeah, I think the case history started, I think, at 140 feet down to 120, down to 100. And then this also the point of the protestants, their concerns, not to say their concerns are not valid, but as I stated before, there are certain concerns that are baked in with the permissible special exception for such a tower. And then the second issue, even if we were to accept that there are such concerns at a location, those same concerns would be at all locations within the RC2 zone. So I know it sounds like legalese, but that's the language we deal in when dealing with the special exceptions. So, and then also, I think as Mr. Pennington noted, out of the 502.1 factors, the health and general welfare is the only one that's really applicable. Most of the time when we're dealing with the special exceptions, we're dealing with traffic, overcrowding issues, which are not germane in this situation. So there's really only one consideration that we heard expert testimony from I believe with Mr. Dugan. So that being said, I believe we are unanimous in that decision. Special exception will be granted. A written opinion will be issued in due time. Once it is issued, in that opinion would be the appeal rights of anyone who would like to appeal that to the circuit court for further review of our decision. With that being said, is there any further business before we conclude?
Nothing here, Mr. Chair.
No, Mr. Chair.
All right, well, everybody have a happy holiday. I'll see you all soon. Thank you.
Thank
everyone.
you. Thank you.